Hi guys, it's Kathy. CJ saved the stream. CJ woke me up. Thank you, CJ. Thank you, thank you, thank you, thank you, thank you. So, we made it to Sunday. We had a great stream on Bell's channel last night. I should get that link. Give me a minute. I'll give you the link to our stream last night. It was awesome. It was such a good stream. We saw so many people there. All right. Linus was there. Victoria was there. All right, I know it's very courty. I know it's very lawyerly. But we're going to continue with this docket because it's really good. And we're going to continue with Judge Ponda, Judge Eric, because he's really good. I'm not muted. I'm not. I don't know who's texting me right now. I am not muted. I know that I'm not muted. I don't know who was about to send me a text, but I am not muted. Here. Judge Johnson
put forth during any of this, and any sort of anything that Mr. Bradley did or didn't say really did nothing to even touch any of that. Even if we are going to consider that any of this is material, and it isn't, right? This is off to the side at very best. The argument here is this kind of confusing argument in the negative, because the fact of the matter is the jury did not hear any evidence of a connection between Washington and Puller. And I get the defense argument is, well, we think we would have been able to make that argument even better, and that may have helped in some way, shape, or form. But again, we're arguing in the negative. How could we possibly consider that the entire outcome would have been different if the jury didn't hear something that they already didn't hear? If they were able to not consider, or if the defense was able to make it a finer point of something that the jury never had an opportunity or never heard from in the first place. And so, Your Honor, all of this is really this kind of confusing roundabout way of looking back that just does not satisfy the elements of the Hopper case in front of you. And the last thing I'll say about any of this is that we have done the diligence to review the phone dump. We just filed the a revised summary with the of both Bradley's opinion and the gang expert's opinion that suggests that what is on the phone is a very strong connection between Mr. Puller and Mr. McPherson, including a gang connection between the two of them, because it's suggestive that Mr. Puller is himself a Piru blood. And so if there's anything on the phone
Linus,
that's material in the first place, I'm not sure that it is.
Man, got it.
It suggests that it helps strengthen the idea that Puller was the getaway driver, and that he did have a strong connection with Mr. McPherson. That those two were acting in concert together, which is already clearly established in the video. So does any of this change anything in any meaningful way? No.
Out of curiosity, did we ever clarify whether or not
You hit man, all right.
Bradley looked at?
I have a members only coming up too.
Yes, he did not.
Soon.
Because when he testified, he was unclear whether he was just wrong on that or whether he had seen it, and he was assuming that he didn't, but it was, all of
Yes.
that was unclear.
Yes, so we did clarify that. We never got the dump. And Mr. Bradley, being a DA employee, only has access to what we, as the DAs, have. He doesn't have access to anything that DPD has that they haven't shared with us. So it wouldn't have been possible for him to look at the dump. He got his wires crossed in a way that he shouldn't have, because there was some Facebook evidence that was screenshots from a phone. And I think that he then got confused, thought he was looking at a phone, and then, as he said, put materials or attributed materials that he was looking at to the wrong, in the wrong place. But he never looked at the phone until we received it from the detectives in the middle of the Washington trial.
And Ms. Stewart, reply.
Your Honor, just to be clear, I have reviewed the phone and I made a record already. There is a critical witness who was in the car and at the hospital whose phone number is in that phone. We are making efforts to locate this person, but to suggest I haven't done my due diligence is just offensive at this point. And I would note on page 5 of the
I'm offended too.
prosecution's motion, in the footnote 2, for the purpose of this response, the people assume without conceding that Mr. McPherson and his attorneys exercised diligence to discover all favorable evidence before trial. Now the record is being made that we didn't exercise any diligence to uncover any of this, and that we're not showing what we need to. The reality is this, is that we had exhaustive conversations about discovery, exhaustive. And we kept asking, do we have everything? And we kept being told, yes. It is not the defense's obligation to challenge and double check that the prosecution is doing their job. What we know right now is that the Denver District Attorney's Office is having issues with discovery, and it just keeps coming. And it happened in this case repeatedly. And in this particular situation, we get a report from an expert saying that he's reviewed a phone dump and that he viewed these videos and he created this report. And it's being suggested that we should have exercised due diligence to challenge that when that witness wouldn't cooperate with us, when the district attorneys wouldn't assist in us uncovering whether or not that information was relevant. It is beyond frustrating. We relied on an employee doing their job properly. And then what we find out is, not only is the information incorrect, that he didn't even know at the testimony stage whether or not he had viewed it or had not viewed it. What comes out later is that he hadn't even viewed the phone because he had never checked it out.
She's sick. She's not crying.
Received discovery today on September 12th, supplemental reports from Investigator Bradley. We received information on September 9th from Investigator Bradley fixing this issue with the report. And it keeps evolving from testimony on the 25th of July, argument on the 28th of July. Then we start getting information sent to us on July 29th that I then have to get access to because it takes hours to download. We have to put it on an external drive. I then spend hours going through this phone to figure out what's actually on there. And there's important information on there. And that particular witness, I can't say what her name is because I don't know yet, because we're still trying to investigate it. As that's going on, I'm still getting new reports from this Investigator Bradley. So as we're trying to play catch up, we did everything we could for 18 months to be properly prepared in this case. It is not an impeachment issue. This is the prosecution's theory in this case, was that because Mr. McPherson and Mr. Washington.
No, Rich, this is a shooting at a bar. I don't I don't think there was a car involved.
Are gang members. They acted in concert together. That they were not acting in
could be wrong.
self-defense. And I understand that the standard says, did somebody else commit the crime? Is this person not involved? In a self-defense case, that gets more complicated, right? That's not the standard in every single case. What we know is that the evidence, the physical evidence, does not point directly to Mr. McPherson. Although the evidence suggests he shot first, it doesn't suggest that he shot all of these people. And the prosecution is relying on complicity to their benefit, but then wanting to say you don't address complicity for these other things. The complicity is part and parcel to this case. Just because they didn't want to get into whether or not Mr. Poehler and Mr. Washington were connected doesn't mean it's not critical for the defendant's case. Because we relied on information that was inaccurate, it was detrimental to Mr. McPherson. It's as simple as that. It's not, would I have gone into this? I would have. There is no doubt in my mind that I would have made a huge deal over the fact that Mr. Poehler and Mr. Washington were not connected. Because this was a complicity and a self-defense issue, that information matters. And we know that a different result occurred in a different trial where all of this information was heard. And it's not just, I know we're breaking it down into 1, 2, 3, but it's the totality of the information that becomes, I think, clear that a jury hearing all of the information would come to a different conclusion. If the court thinks I need to go into more of prongs 1 and 2 about when this information was discovered and whether or not we exercise due diligence, I'm happy to go into that again. But we have made efforts to get this information correct.
All right, your self-defense argument?
Your Honor, as to self-defense, when it comes to this particular prong of it being the connection on the phone, or I'm sorry, the information about the phone, I do think whether or not there is a connection between Mr. Poehler and Mr. Washington is relevant, again, to whether or not these people are acting together. The argument from the prosecution is that Mr. McPherson was the initial aggressor. Everything that we know from the start of this was that Malia Hill was the daughter of Todd Washington. Todd Washington gets a call. He comes over to handle whatever situation happened with his daughter. Mr. Washington approaches the bar with a weapon. It is the testimony of the witnesses that Mr. Washington is the one that's talking about having 30 rounds for this person, not Mr. McPherson. The suggestion that Mr. Poehler is a getaway driver, again, creating a separation between Mr. Poehler and Mr. Washington, would help Mr. McPherson's argument with self-defense that he was acting on his own, not with Mr. Washington, that his perception of self-defense was completely separate from whatever was going on with Mr. Washington. Mr. McPherson, in the video stills, you can see there is a gun pointed directly at him, and there are 2 other guns drawn and directed by Mr. Washington to Mr. Batts, and there's a gun in Mr. Batts' hand. Then there's a weapon from Manuelito Vigil pointed directly at Mr. McPherson. The suggestion that Mr. Poehler is a getaway driver and somehow connected basically makes everything more convoluted for the argument that the prosecution made, which is that this is a gang-involved situation and that there was some type of agreement for them to work in concert together. Separating Mr. Poehler from Mr. Washington allows for a jury to look at Mr. McPherson more as an individual rather than as part of a group. And if he's looked at as an individual, whether or not his perception for self-defense is required is a different analysis on it than if he's working with Mr. Washington.
He's pondering. He does that. I miss Mike out every time Eric ponders. He's not pondering to give a ruling because he's going to ask someone else to talk next.
I have a hard time following this argument, to be completely honest. And it seems like it's really just rehashing what we've already discussed. Once again, the jury didn't hear about any sort of connection between Washington and Puller. So to argue that the whole thing would have been different because they would still not have heard that really doesn't track. And we didn't make an argument that there was a connection between these individuals because of cell phones. And what may or may not have been on a third party cell phone is not dispositive of anything. And it isn't the sort of smoking gun that the defense, I guess, is trying to argue that it is, because we argue there's a connection based upon what the eyewitnesses said. We argue that there's a connection based upon their tattoos, their street checks, their shared gang involvement, and we argue that there's a connection based on the video. That, as Your Honor has said many, many times, is what this case is all about. And so I don't really understand the hair we're trying to split here with any of this. And to the extent that the argument is about jury instructions, that's not newly discovered evidence in the first place. I don't know how it even relates to a Hopper discussion. So unless Your Honor has specific questions, I don't want to repeat myself more than I probably already have.
Mr. Anything?
No.
Last word on the third issue?
Is he chewing gum?
Your self-defense argument, the third.
No, apologies, Your Honor. I'm just,
Yeah, long day and you're sick.
yeah, no, I don't have any further record as that.
All right, then to finally wrap it up and make your big picture totality, put all that in one place. Final argument.
Your Honor, for the totality argument, I would just tell the court it, without trying to repeat myself too much, this is a case where the prosecution has argued, and they again started to argue that, because both individuals are gang members and they have similar tattoos, that the video shows that they go near a car, that that's enough for complicity, and that they're acting together and approaching. And the clear argument from the prosecution is that they were not acting in self-defense and that Mr. McPherson could not have been acting in self-defense because he was the initial aggressor and shot first. I think looking at the names of the witnesses that were disclosed, the reality for us is that they were disclosed after the trial. We know that these are individuals who were present in the parking lot, who would have been able to testify as to the circumstances in the parking lot, and whether or not conversations were overheard, and whether or not these individuals, being Mr. McPherson and Mr. Washington and Mr. Puller, were acting in concert together. I know the prosecution wants to say that Mr. Puller is a third party. They brought Mr. Puller into this trial. They argued that Mr. Puller was part of this trial. So to suggest that we're not entitled to discovery that's part of this investigation into this case because he is a third party that was dismissed at one point. This was still evidence that was collected in this case. And they still argued that Mr. Puller was a critical piece in this case and that his actions of walking up to the car with Mr. Washington and then later getting into his vehicle to drive away, that was, he was the getaway driver, that he's acting in concert with these people. So to have 8 other witnesses that were in the area, who some testified, some didn't, being able to present that evidence to a jury is critical. You add in the fact that we have a investigator, Bradley, who produced a report saying that there were videos on Mr. Puller's phone that connected him to Mr. Washington, that information was relied on in good faith. Clearly, I should not have done that, and the suggestion is that we need to challenge every report that is done at this point. That's for a different day, but what we know is that defense did not go into the connection between Mr. Puller and Mr. Washington because it was detrimental to Mr. McPherson. It would have been extraordinarily helpful for Mr. McPherson to be able to argue that there was no connection between Mr. Puller and Mr. Washington. It would have put more distance between this argument that the prosecution made of a complicity theory. The self-defense component of this goes to the fact that you have no audio, you have video of people outside of the club, guns are present. I think as the court stated at some point, it was like a tinderbox. There was just, there was a lot going on and people were, their guns were ready to be pulled. And this all happens in less than 2.5 seconds. The reality is, if we were able to present evidence of these additional witnesses and the lack of connection, whether or not Mr. McPherson was acting individually as to self-defense would be critical. the fact that we were not able to argue that Mr. Washington was also acting in self-defense prevented Mr. McPherson from being able to have the jury consider. It's hard because on the one hand, the prosecution argues that they were acting together, and that because they were acting together, you can consider both of their actions for guilt. But if they're acting together in self-defense, that argument wasn't allowed to be made to the jury because of the way the jury instructions came out. I think the court made a record that we didn't know if Mr. Washington was going to get a self-defense jury instruction. In my motion, I did note that Mr. Washington was granted the right to argue self-defense. And so I think the reality of Mr. Washington being able to argue self-defense, having these additional witnesses, the totality of it would have resulted in a different outcome for Mr. McPherson. And the closest thing I can tie that to is that there was a different outcome in Mr. Washington's case when all of that information was considered in its totality. Is the court okay if I sit down for a minute?
Yeah, you can argue from,
Sorry,
Yeah.
it's just getting shaky.
that's fine, you can argue from the desk.
For right now, that's all.
All right, last word, Mr. Freeberg.
Yes, Your Honor. The defense did argue that there was no connection between Washington and McPherson. They argued it over and over and over again. That was essentially the entire closing argument. We didn't produce any evidence of a connection through Polar. We argued, as I've described otherwise, that the rest of the evidence is suggestive of that. And so there's nothing that they have outlined that would have materially changed any of the arguments that anybody made. And they just haven't been able to show you otherwise. As it relates to these witnesses, perhaps the defense does know something that we don't about these witnesses and just hasn't told you about it because they've identified 8 people. As I indicated, I still don't know. We still don't know.
She's going to
who all
punch
these
him
people
if he
are
doesn't
and whether
stop.
they have any sort of material evidence. Right. So just to go through it, 6 days, Amanda Schultz testified she was on the video. She was an eyewitness. We didn't know about that until after the McPherson trial. 6B is Harwath Singh. I had no idea who that is. And whether that person has anything material. That. 6C is Essence Russell. I don't know who that is and whether that person has anything material to add. 6D is Ray J. McClellan. Ms. McClellan testified at trial. She was an eyewitness. She was on the video very, very, very briefly. We didn't know about that until afterwards. Victoria Lopez, I believe, is Manuelito Vihil's girlfriend or common law wife. I don't know why she was endorsed. Jamiri Davis indicated, I believe that he is a member of the Hell's Lovers who indicated he was in Pueblo at the time. I have no idea why he was endorsed or whether he has anything material to say. Madison Afterburn, we believe.
Yeah, but isn't that his job to know that? He's prosecution. They gave a witness list. I'm sure when they give a witness list, they give a small snippet of what they expect from that witness. Isn't it his job to figure that out? He's telling the judge he doesn't know what these witnesses are for.
Is the significant other of John McNeil. I don't have any other information about whether she was present, whether she has anything to add. I don't believe she was on the video. I don't know why she was endorsed. And I don't know who Benjamin Forsyth is and whether that individual has anything material. So, again, what we have to look at here is is there a probability that the outcome would have been different? And the onus is on the defense here. And they have not done nearly enough to show you that there probably would have been a different outcome if any of this stuff would have come out or not come out, as it were, during the trial when we were focused on far more relevant, far more important things. And so respectfully, Your Honor, all of this should be denied. We should proceed on to sentencing.
I remembered for once to hit my own like button because I knew I was going to like this. I know it's not crazy court crying. I know that. It's pondering. Pondering with a gold statue. I don't even know how many people are watching right now, so there's no way I know how many people hit the like button. You guys actually really don't have to hit the like button if you don't want to. You really don't. It doesn't. On live streams, this is just for fun. I would like to know what he highlighted with that. I would like to know the notes in front of him and the highlights that he makes on his notes. I would love to go and have 7 beers with this judge so much.
Ms. Stewart? Last word of the last word?
You already said that, Judge.
Your Honor, I don't have anything else at this point as to the new trial motion. And I'm sorry, I was going to ask the court if we could maybe take a 10-minute break. If the court wants to keep going, we can. I'd ask.
It's going to take him 10 minutes to ponder whether we should take a 10-minute break. He comes up with an answer, but it's wrong. But the prosecutor's going to get punched by this defense attorney if he doesn't watch it. He's just trashed her over and over again. There is a video, and this guy 100% started shooting first. He's a gang member. They're at a bar. He starts shooting, and then the gangs all pull out their guns and start shooting. And now the defense is saying, "Oh, self-defense." Self-defense. But this gang member wasn't even at the bar that night. His daughter was. And his daughter calls him up and says, Daddy, help. Ah, pity no. Pity, get down. His daughter calls him up and says, Daddy, help me. So Daddy comes with a gun. And he does try. He does try to calm the whole situation down. The father does. And then he pulls out his gun. Oh, yeah, allegedly. No, he's definitely a gang member.
Tell you what we'll do. I appreciate Ms. Stewart's well, dedication to her client and her toughness for being here, even though she's sick. Probably could have asked to continue this, but understanding how important it is to you, she came here and battled through. I had planned on taking a bit of a break, collecting my thoughts, and then ruling. But I think what I'll just do is we'll just set it for September 26th for me to enter judgment. So we'll just come back on the 26th for judgment, if that works for everybody. And that way, hopefully, Ms. Stewart can take care of herself, not be sick, but we'll enter. I'll probably end up making a better ruling, taking my time and collecting my thoughts anyhow. But yeah, no, I was thinking the 26th, I could do it late morning.
I'm not available the 19th. I have 3 other court. Yeah.
Yeah, we
Sorry.
can do it at 11 a.m. on September 26th, if that works for everybody.
Well, Your Honor, respectfully, we would ask not to. And the reason for that is we have victim family members who have traveled in from out of state to be here for sentencing. This is the second time that they made that trek. Obviously, this is really.
Oh, I said, all right, so I didn't realize that.
Yeah, obviously, this is really important and we need to make sure that we get it right. But it was their sincere hope that we would get to sentencing. Several of them want to speak.
Oh, okay. All right. I did not realize we had family members here. All right. Why don't we?
Kelly,
I was going to push.
yay. What happened
right,
with
we'll
your
deal with it.
computer? Was it the cat?
Um,
It was the cat, wasn't it? Damn
We
cat.
give you. We take a 15-minute break. Is that enough to get yourself?
Yeah.
Okay, we'll take a 15-minute recess.
All right. This is not forgiving, so here we go. Judge, you had plenty of time to ponder during your break. Can you just stop now? I can see him gardening, but I wonder where he hangs out, like what type. He doesn't hang out at a bar. He is married with children. And I think one of his daughter, I think, is special needs. Or she has mental issues. I know she has mental issues. No, they want a new trial. They want to suppress some evidence in this new trial. It was the cats, Kelly.
The issue before the court is the motion for new trial filed by the defense on August 11th. Mr. McPherson had a trial in which he was found guilty and verdicts were received on July 2nd.
I know we saw some of the trial. I know we did.
I would note that for motions for new trial for issues other than newly discovered evidence. These should be filed within 14 days after the verdict. To the extent the motion brings up issues, well, not to the extent, it does. The motion brings up two issues, one about how Mr. McPherson was instructed, how the self-defense instructions in the complicity case were formulated, and the issues with Mr. Bradley's testimony. Mr. Bradley's testimony in the Washington case was on June 25th. Well, I don't know if the Bradley issue would be considered. The point I'm making is for everything except newly discovered evidence, there's a 14-day time period. This motion was filed outside of 14 days. That being said, to cut to the chase, in criminal matters, these 14-day time periods aren't jurisdictional. It does not preclude the court from addressing them, so the court will address the issues as raised in the motion. The first issue raised by the motion is that there were new witnesses who were, well, there were names of witnesses were given to the prosecution by the defense of Mr. Washington. And that when the defense found out who these witnesses were, they realized that there were a lot of people there that they hadn't heard of before, did not know who they were, but it turns out through the Washington trial, it became evident that at least two of them who testified, I believe Ms. Schultz and Rajay McClellan, testified that they were there and saw some parts or portions of the events on that day. The defense has argued that well, a couple of things. One, that there was a delay in the timing that when the DA found out about the existence of these witnesses to when the DA formally told Washington counsel that they knew. Sorry, there is a delay in the time from when the DA found out who Washington's witnesses were, previously unknown to the prosecution, that there was a delay in letting McPherson counsel know that they now had names of witnesses from Washington that they hadn't previously had. I would
It was
note
Pitty. Pitty's the one that did it.
that Mr. Washington, through his counsel, apparently refused to give the names of these eyewitnesses to McPherson's counsel.
That's not good.
The defense has argued that these witnesses are important because these witnesses could add or would add to their argument that there was no connection between Washington and McPherson. On this basis, the court denies the motion for new trial. I think the prosecution is correct in that under Rule 16, there is no obligation for them to turn over some other defendants' endorsed witnesses, especially when they have absolutely no idea who these people are. On June 17th, the prosecutors would have been neck deep in preparations for trial for Mr. McPherson, which started on the 22nd. Something gets filed, it makes it through the ISIS system, it gets to them. I guess it's unclear to me exactly when the prosecutors even knew of these witnesses, but all that would have been given to them would have been names and addresses. And so they would have had no idea that any of this was, these all could have been character witnesses for Mr. Washington. The prosecution had no idea, no obligation to turn it over. It is unfortunate that co-defendant did not see fit to tell his attorneys to let Mr. McPherson know about these witnesses, but that's not the prosecution's issue. And I suppose a court cannot blame Mr. Washington for looking out for himself and not caring about Mr. McPherson. That's not his job either. So the motion as to that first issue is denied insofar as some delay in turning over information that they had no obligation to turn over. The record does indicate that at some point after the McPherson trial, the DA's office digested this information, began doing some information and or began doing some investigation. And by October 5th, Mr. McPherson, through his counsel, received summaries of investigation and some results of interviews, apparently, and things of that nature. To the extent that the witness issue bears on, well, look, the standard for the motion for a new trial. I mean, not only, I mean, I appreciate the Hopper court giving us the 4 prongs to help guide trial courts. That's always very helpful. But the rule provides a standard that a new trial is, if I can grant a motion for a new trial, if it is required in the interest of justice. And this really is a matter of discretion for the court and the function of the court's sense of fair play and, you know, what was right. Was this trial really somehow compromised? And to that end, the defense argues yes, because the DA's argument was that Mr. McPherson and Mr. Washington acted in concert as an OG blood and Mr. Washington and a soldier, Mr. McPherson, acting together through a complicity theory, and that these witnesses could have shown established more affirmatively, that there is no connection between Mr. Washington and Mr. McPherson. The evidence in the McPherson case was that there was no connection between them. That is
not true.
That was the state of the evidence.
No, it wasn't.
That was the answer to the jurors' questions. That was the answer.
Wait, no, but didn't they prove that they had like these matching tattoos, and I think it was just tattoos. Maybe if they just have matching tattoos, that doesn't mean they're affiliated.
That Mr. Bradley gave, and nobody at any time argued other than the gang connection and the inherent obligation of a soldier to respond to an OG's call. No one argued there was a connection.
Isn't that a connection?
The
That is a
prosecution didn't
connection.
even argue that there was a Washington Polar McPherson connection. They did not make that argument. The defense has summarized the prosecution's case as saying a 10-second meeting at a car was enough to create, is all they had for complicity. And I think that misstates the evidence available to the jury. The jury saw the videos. None of them had sound. Obviously, there is sound. Jury very easily could have inferred that there was talking, there was yelling, there was screaming. We know there was yelling at some point from Mr. Washington's daughter. There could have been discussions. There could have been people yelling things. There's any number of ways that Mr. McPherson could have found out that Mr. Washington was who he was, even if he didn't recognize him, and beyond the conversation at the car. So to say that the evidence of complicity comes down to Washington walks up to a car and McPherson walks up to a car minimizes things to an extent that I think distorts the actual evidence that was available to the jury that they had to consider of complicity, to include, let's even assume that it is purely speculative that Washington is talking, that Washington is yelling, that Washington said anything. The evidence is that Mr. McPherson was around, was walking around that parking lot. He was walking with Mr. Puller. He apparently would have been aware by being there of what happened with Mr. Washington's daughter. Mrs. Washington's daughter was recognized as someone who was related to Washington. Came out in the Washington trial that people recognized and actually said that is, using Mr. Washington's moniker, that's his daughter. So she would have been known. She would have been recognized. She would have been seen.
What do you mean,
Mr.
no
McPherson
sound?
had been
You
walking
can't
around
hear?
that parking lot for a significant period of time, walking
Did I lose
together
sound?
with Mr. Puller, and then in very short time, Mr. McPherson does go up to the car that Mr. Puller is
The video.
in,
Got it.
then
I
walks
caught up.
across
I
the
got there.
parking lot, times his entry to the corner where he positions himself at or about the time that Mr. Washington is showing up to confront the Hell's Lovers. And then the jury would have seen how Mr. McPherson is acting while Mr. Washington was there. The prosecution argued that Mr. McPherson took a cover position. And then because it becomes relevant later, they argued, really, they don't have to argue a connection between McPherson and Puller. They were walking around together. It's obvious they were together. And then insofar as the getaway driver aspect goes, that wasn't based on any analysis, no Facebook, no phones, no nothing. That's just based on the look at the video. The car pulls out, the car waits. Mr. McPherson goes to a specific location. The car is waiting at a specific location that is easy for Mr. McPherson to run to. When the shooting starts, Mr. McPherson indeed does run to the car, and then the car takes off. So the evidence of complicity went beyond just a conversation at the SUV. And really, the complicity argument that the prosecution made never looped Mr. Puller into it. That was just never their argument. I do, well, the second basis given for requesting the new trial is the testimony of Mr. Bradley in the Washington trial. In the Washington trial, Mr. Bradley affirmatively testified as to a connection between Puller and Washington. In error, by mistake, which required him to take the stand and admit that that information was wrong, that it did not exist. I acknowledge the defendant's argument that had they known this, that they did have the Bradley report, that they would have, and I have no doubt, because this was the defense, a huge part of the defense case in the McPherson trial, that there is no connection between McPherson and Washington. I have no doubt that that would have been gone into by the defense, that they would have had that report by Mr. Bradley not been issued in error, that the defense would have dotted that I, that there was no known connection between McPherson. No. There was no known connection between Washington and Puller, which then could be attributed as a connection to McPherson, Washington through Mr. Puller. They would have made that clear, I'm sure. But the evidence that came out in the McPherson trial was there was no connection between anybody. There was no connection between, the testimony was there was no connection between McPherson and Washington. The evidence that came out was that there was never any argument that McPherson through Puller is doing the bidding of Washington. That was not the argument. It never came up. The argument was, and remained very steadfast, OG blood, Mr. Washington, there's an issue going down, soldier comes to his help. Whether it was explicit or implicit, whether he invited himself in out of a sense of duty, or whether somehow Washington, in the audio we don't hear, yelled it, communicated it, whether it was communicated through the car that they talked, we don't know. But the testimony of the experts was that the soldier would have been duty bound to help, and he was there. He saw something go down. He saw, the complicity had nothing to do, the complicity argument never implicated Puller whatsoever. And so, though I do acknowledge, and I assume as true, that the defense would have said, and well, they did do the line of questioning, there's no connection between McPherson and Washington. I have no doubt they would have said and highlighted, there's no connection between Puller and Washington. But in the end, that wasn't the theory of that wasn't the basis of the complicity theory, that again, that Washington is working with, that McPherson is working for Washington through Puller because he knows Puller is buds with Washington. That wasn't the theory of the case. And the jury was presented only with information that there was no connection between anybody except the obvious connection between McPherson and Puller because they're seen walking around together. So the motion for new trial on that basis is also denied. And I guess real quickly, I do acknowledge also that had he made a mistake in attributing a connection, that he, Mr. Bradley, did make a mistake in establishing a false positive connection between Puller and Washington. Had that been known to the McPherson Council, again, I have no doubt that they would have brought up the fact, you know, you work for the DA, you're supposed to get things right, and you blew it. You got it wrong. And he would have had to admit that. But I don't know that can be attributed to a false negative. It would have showed that he made an error, but in the end, his testimony was there is no connection between McPherson and Washington. And what is the inference to be gained by he made a false positive connection before? That somehow his false negative is wrong? That somehow there is a connection between Washington and McPherson because he blew that too? But no, his testimony was there's no connection between McPherson and Washington. So notwithstanding the case law cited by prosecution, which I agree that's what it says, insofar as, you know, trial court doesn't hang its hat if the purpose is purely impeachment of credibility, but at a fundamental fairness, had this information come out, as to Mr. McPherson, it just wouldn't have moved the needle in this court's assessment. The third assignment, or the third reason given for the motion for the new trial, has to do with an issue that I think I brought up during jury when we were fashioning the jury instructions. The issue, as I understand it, deals with, and we will just take instruction number 23 as an example. Complicity is not a separate crime. It's rather a legal theory. For the defendant to be guilty as a complicitor for murder in the first degree, prosecution would have to prove beyond a reasonable doubt, 1, another person committed the crime; 2, the defendant with the desire or purpose or design to aid, abet, advise; 3, aided, abetted, advised, or encouraged; 4, the defendant was aware of the elements of 1 through 5, which are listed below, and the defendant's conduct was not legally authorized by the affirmative defense in instruction 19, which is self-defense. Well, we call it self-defense, but it's use of deadly force in defense of others. The complicity instructions go on to say, for the purposes of the instruction, another person committed the crime of murder in the first degree if the prosecution proves the other person in Colorado, after deliberation, with intent to cause the death of a person other than himself, cause the death of a person other than himself. And I wondered whether or not we had to put in a 7th element, and that person's conduct was not legally authorized by the affirmative defense of self-defense, defense of others, use of deadly force, and whatever it would have been. And the defense is saying that, yes, we should have included, just colloquially, I'll say, the self-defense instruction there as element 7 as to the complicitor elements in the complicity instruction. And I'm going to deny the motion on that basis as well. I don't know what a superior court's going to say is the answer to that question, but asking a jury, the jury was told that Mr. McPherson, even in the, well, as to the other instructions, instruction 16, which was murder in the first degree, McPherson as an individual actor, they were told they are allowed to look at instruction 19, which says he was allowed to use deadly physical force in order to defend himself or a third person from they reasonably believe to be the use or imminent use of unlawful physical force. So as to him as a principal, he was given self-defense. And then as to the complicity the jury was again told that Mr. McPherson was allowed to use deadly physical force in order to defend himself or a third person, Mr. Washington, from what they, Mr. McPherson, reasonably believed to be the use or imminent use of unlawful physical force by other persons or other persons acting in concert with that other person. So he was already, the jury was instructed within the complicity instruction that he could look at the threat to Mr. Washington in determining whether or not the jury thought Mr. McPherson was acting in order to defend himself or the third person. I think it is
Okay, yeah, but all of them
confusing.
were acting to defend themselves because he started shooting. He's the one that started shooting. You can't go to a bunch of gang members, start shooting, and then claim self-defense. That's stupid. That's ridiculous.
Incredibly confusing for a jury to have to decide whether Mr. Washington had a right to act in self-defense, given the evidence admissible on that issue was limited because it's not Mr. Washington's trial, it's Mr. McPherson's trial. And there's evidence that came in Washington that didn't come in McPherson, the other way around. And suddenly, just because it's complicity, does that mean every single piece of evidence as to the other complicitor comes in as it's relevant to self-defense? And then a jury has to decide whether Washington acted in self-defense, and then how did that affect what Mr. McPherson knew or his state of mind, when the issue in the McPherson trial is Mr. McPherson's actions and his mens rea. And the jury was instructed that Mr. McPherson could assess the entire situation. He could assess the threat to Mr. Washington, the third person, and if he reasonably believed that deadly physical force was necessary to defend himself or the third person, Mr. Washington, that he could use deadly physical force. So he was allowed to assess self-defense. He was allowed to assess the threat to Mr. Washington, and the jury determined that Mr. McPherson's actions were not
Shut up, JK.
excused by that affirmative defense. I know it can be hard to have heard that the OG had a hung jury on the issue of the intentional, deliberate, and the extreme indifference. I think he was walked on. It was the intentional, deliberate as to counts 1 through 4. Those were the intentional, deliberate counts as to the two, whatever. It's counts 1 through 4 that they hung on. But that did not come down to any of these issues. The who is an initial aggressor is the initial aggressor, Mr. Washington, when he walks up and says, send out that pale beanie wearing N-word. I've got a 30 with a 30 for him. And then that person comes outside and within 5 seconds, he's dead. Or is initial aggressor from Mr. Washington's standpoint, he says, send out the N-word. I've got a 30 with a 30. But then there is testimony that Mr. Washington was calm. Testimony in the Washington trial was that McPherson was the agitator. And then the evidence shows, I think it cannot be questioned, the evidence shows that Mr. McPherson fires first, which then opens the door to a self-defense argument by Washington that Mr. McPherson does not have, because once McPherson shoots, now a fire has, a shot has rang out. And is Washington reacting to that? Does that make McPherson the initial aggressor? Part of this gets very confusing for a jury, because this is one of those moments where when you slow everything down, as the things get slowed down, it ends up distorting the truth as to who really is reacting to what, or is the evidence really that McPherson and Washington are continuing to act together because you see they're shooting in the same general directions and whatever else, and things are happening too fast for anybody to have been really reacting to that. But anyhow, that's an issue for a jury. The bottom line is that Mr. Washington has a colorable, even if the court's estimation unlikely, argument of self-defense. The case law says if there's any evidence to support, we have to give that. So it was given in the Washington case, because if the jury the case could be made that the jury believed the one witness who said Washington was cool, he was calm. It is clear McPherson shoots and then Washington shoots, and hey, he's shooting and just to defend himself. The links are there, however unlikely. And so the self-defense was given, but that argument does not exist for Mr. McPherson, because it's on video. He shot first. And whether he did it on his own as a principal, or whether he did it on being a good soldier, coming to the defense of the OG, I don't know. It doesn't matter. He does not have the facts as they came out in Washington. The facts as they exist in the case just are qualitatively different for Mr. McPherson. So the self-defense basis for the new trial is also denied. The totality argument, none of these things, even if there was any error in any of these things, altogether, cumulatively, would not have moved the needle. The testimony from the two people that were unknown to the prosecution, that were eventually known, that were known to Mr. Washington, who was not given to Mr. McPherson by Mr. Washington, did not testify in a manner that would have been helpful to Mr. McPherson at all. I have no idea who any of these other people are or what they would have testified to. The Bradley situation, the lack of ability to impeach when his testimony was there is no connection, would not have changed anything in the self-defense. I think the court got it right. I think I got it right. So even cumulatively, there's no reason to grant a new trial, and so that motion is denied. Are we ready to proceed to sentencing then? All right, to that end.
Time for sentencing.
Prosecution.
Your Honor, we have several members of Michael David's family present in the courtroom. I also have a statement by Nikita Batts, who is present via WebEx, that I would like to read. But first, I would like to have Mr. David's family come and give a statement. So I would invite up Lydia David at this point.
We saw the end, the jury. We saw the closing statements
Hi, good afternoon.
and the judge speaking
My name is Lydia David,
Like,
Lyda
in July.
David.
for this trial.
I am the daughter of Michael David, who was one of the people who passed during the shooting, and I am his eldest daughter and just his eldest in general. Sorry. I miss the calls that I get from him now. I used to get random calls from Michael, and it was always silly and it was great, and I don't get them anymore. I save a voicemail, the very last voicemail that he left for me before that, and I make sure to save all the gifts that he got for me. It's in totality made me realize how much I should treasure what people give me, because he cared a lot about me, and he cared a lot about a lot of people. He was always so passionate about what he was doing, and he always tried to do the right thing. I remember he did this thing with like cups to try to tell me that I should um to try to like guide me to basically go to college, because he wanted to make sure that I had a good education so I could get um the job that I want and everything. And when I went to his memorial, I heard about all these stories about him helping people constantly and always trying to help others. Um, yeah. So I think that's what I should say, if that's about what I'm supposed to. Sorry. Like, this is obviously from the heart. I do love him, and I wish he was still here with us today, because I do miss him. But
Thank you very much. I appreciate your appearance in court.
Your Honor, the next person I would invite up is Michael Rose.
My name is Michael Rose, and I'm Mike's youngest son. And I didn't get to know Mike, but I got to know the best parts of him. And like when I heard that he had gotten shot and died, it was the worst thing ever. And like I don't think I realized like at the beginning how much it was. Like he'll never see me graduate. He'll never see me get a wife and kids. And he can't help me with the problems I'm having now. And I see what it's done to my family and everyone around it, and I try and stay strong, but it gets hard. And that's about all I want to say.
Thank you very much.
Next, Your Honor, we have Zacchaeus David.
My name is Zacchaeus David. I am the eldest brother of Michael. I am Mike's son. I knew him for a very long time. And in the last final years that he lived, he tried to do his best. And he tried to really put effort in to all of us. At first, it was tough for him. And he was able to admit that and take fault for that, which I adore that from him, because I never really got to see that side of him. And my brother Michael, he only got to see the good, which I'm so happy for. But after losing him, it fractured friendships, and I think it fractured me, because 3 days before the incident, he texted me and he said, "Hey, I need you to call me." And this was, my sophomore year of high school. And I was like, I don't need to call him. It's okay. And I wish I did. And I never have that chance again. And I wish I did. And I just can't take that back. And I can at least keep the memories, at least the good ones I have. But I know some of the bad ones should stick with me, so I know how much he changed for us and his family.
Give yourself some grace. Don't beat yourself up over that lack of a return phone call.
Thank you.
Thank you.
Your Honor, next we have Melissa David.
Hello, my name is Melissa David, and I wanted to say that I grew up with my dad, Michael David, and I treasure the memories that I have with him. We went on a lot of trips, and the most memories that I really do like is him picking me up from school, and we go to home and we play video games, and I try to beat him. And I love my dad, and I would like to say that I treasure the most happy times with him. Thank you.
Did you ever beat him in a video game?
What?
Did you ever beat him in a video game?
Once.
Which game?
Naruto, I think.
All right. Thank you very much for your statement.
Your Honor, next we have Jackie Hopper.
Your Honor, thank you for allowing me the chance to speak today. My name is Jackie, and I'm the mother of Lydia Rose David and Zacchaeus James David. Of course, they were the children of Michael David. He was a very important part of his children's life, and I just want everybody to know that his death really has left a lasting hole that cannot be filled. I ask the court just to remember that while Michael may no longer be here, his children live every day with that pain of his absence. This crime did not just take away his life, but it altered theirs forever. I am sure that there are some things that he could have handled differently that night. But no matter, he did not deserve to die. There was no mistake, no disagreement, no situation that justifies the hate and the violence that was shown toward him. Now, my children are facing every milestone, including birthdays and school achievements without him. Our daughter, Lydia, just turned 18 this year, and she graduated high school. She just started college this last month. Our son, Zach, he will graduate this coming May, and he has plans to further his education as well. Michael would have been at both of those graduation ceremonies, and he would have been very proud of their accomplishments. He would always gush to anyone who would listen about his children and those accomplishments. There are so many life moments yet to come that they've been robbed of. He won't be there to teach them, guide them, cheer them on as fathers are intended to do. This loss is something that they will carry for the rest of their lives. This crime has changed us forever. My children are never going to get back what they have lost, and every day we live with the reality of what was stolen from them. I truly hope that Mr. McPherson thinks not about just my children, but all of Michael's children. He had a wife, he has a mother, a father, he has 2 siblings, as well as countless other people who loved and considered him a friend every single day. And I just also want him to remember that he has left us to carry the pain of those bad choices that he made that day. And thank you for your time.
Thank you.
Your Honor, next up is Deanna Shute.
Your Honor, let me introduce myself as the adopted mother of my 16-year-old son, Michael Rose. My son was born Michael Richard David III, with the biological parents being my sister and Michael David. I knew Mike a couple of years before my son was born. Just shy of my son being 6 months old is when he came to live with me. It was pretty early on that my son had begun to ask questions. He knew something was very different about our family dynamic. Through the years, I had told him that once he turned 16, we could visit the idea of reaching out to Mike. In 2020, at age 10, my son sat me down and said, "Mom, I get good grades. I have a good head on my shoulders, and I'm a good judge of character." He went on to say, if it only becomes by putting a name to a face, then so be it, but asked for the age to meet Mike to be reconsidered. After so many choices had been made for my son's life, it was important for me as his mom to honor his choice that he wanted to make for himself. I reached out to Mike through social media, and without hesitation, he was on board. Mike remained respectful of certain terms that were set in place, as he knew I was very on edge and uneasy for these changes. Anyone who saw the two of them together couldn't deny their bond. It was quite beautiful. It was as if you saw someone at two different ages of their life, not only with looks, but with jokes and conversations they would have. These occasions only were able to happen a couple times a year because he lived a few hours from us. It was Mike who put in the efforts and to ensure that they did happen when they did. As a person who knew Mike before the birth of my son up to that point, you could just see how much he had evolved as a person. After countless conversations, I can tell you from his words, it was through very hard work and most of all, his established relationship with Jesus Christ. It's important that I speak of Christmas of 2022. My son Michael has an older brother and sister who we've always known and kept in contact with through the years. Along with their mother, we've had our own little family dynamic. I had invited them to come to Wyoming for Christmas, so they did. While we were celebrating the day, their mother received a phone call from Mike. He had spontaneously showed up on their door, so I extended the invitation for him to come the extra hour, and again, without hesitation, he did. It ended up being a wonderful Christmas day. It was the first time my son had ever gotten the chance to be with his older siblings and Mike together. If only we knew then, it wouldn't only be the first, but because of the choices that the defendant made, it was the last. My hope is that on Christmas Day for the rest of his life, that visions of these children being together play through his mind. They will never have the chance for it to be the four of them with their dad. I was at work in the ER when I received the call that November night. I remember it being such a still, dark ride home. I will never get the look of my son's face out of my head. My son has been robbed, along with his siblings, on so many levels. He has been robbed of having the chance of having his siblings and Mike together again. He's been robbed of having Mike at his graduation from high school. He's been robbed of hugging him at his wedding or having him present at the birth of his future children. He's been robbed of having a good night's sleep. Since November of 2023, he struggled with ongoing nightmares. In addition to that, he's severely struggled with anger. He has had medical treatment that is still ongoing and more so now. My son has looked at the people who love him the most, including myself, and states, I don't want to be angry anymore. These are things that he is and wants to work on. My son recently made the choice to move to be with my brother and his wife, who lives in a community that can offer better resources for this and different opportunities in his life. He did that because he wanted the choice as a child to not be angry. It was a choice that was requested by my son because he wants better for his life. The choices that Mr. McPherson made that night has had such an impact on my son's life. As his mother, it was important to me to be a voice for him. Although this tragedy will be a part of his life for the rest of it, it is my prayer that after today, it will bring some peace and closure to not only him, but his siblings and their mothers. I don't have this written down, but it wouldn't be me to say that as a Christian woman, regardless of the outcome today, I do hope that a positive for Mr. McPherson somehow comes out of this.
Bad intent.
And with those decisions, ended the lives of two people who deserve to live.
I don't know why it stopped.
to impose the sentence of life in prison.
Ability to impeach.
The gang expert's opinion that suggests that what is on the phone is a very strong connection between
No, the cats are nowhere
Mr.
near it.
Poehler and Mr. McPherson, including a gang connection between the two of them, because it's suggestive that Mr. Poehler is himself a Piru
I don't know why it stopped.
blood. And so
I don't know where it was. Oh, here we are. Here we are. This is it. Right. No, this can't be it. No. We went through 2 hours yesterday.
5th.
Right. Okay. Yeah, I moved it.
Here, the area being an area.
Okay, I'm just going to closing arguments now.
Absolutely a proper inference.
Going to closing arguments and then the verdict.
Family.
30 days.
I'm
I think
trying.
we have a 20-day deadline on our end. And it was my understanding.
Here we go.
But it wouldn't be me to say that as a Christian woman.
All right, we heard this before, but we'll catch up
Regardless
in
of
a
the
second.
outcome today, I do hope that a positive for Mr. McPherson somehow comes out of this. I used to be an employee of the prison system, and they offer a lot of opportunity. And I hope he takes advantage of that. And, God's always there.
Thank you very much.
Yep.
Your Honor, we have one more family member that would like to speak, and that is Andrea Rager.
Hi, Your Honor. I was Michael David's wife. This whole tragedy has been so difficult and probably the hardest thing that I've ever had to deal with. But because I am a Christian and I love Jesus more than anything, I would like to read a letter that I wrote to Sean. Dear Sean, I write this letter with a heavy heart. I wish I was meeting you under different circumstances. I know this is so hard for everyone, including you. You made one split decision and it changed lives forever. You took away my husband and a father. I'm not happy that you did that, but I want to tell you that I forgive you. I forgive you because Jesus forgave me of all of my mistakes I made. Jesus calls us to forgive. I want to tell you about Jesus's forgiveness for you. John 3:16 says, "For God so loved the world that he gave his one and only Son, that whoever believes in him shall not perish but have everlasting life." He died for you, Sean. He knew you were going to make terrible mistakes, but he loved you anyway.
And I'm sorry. Look, this is an opportunity for you to tell me about how the crime has affected you and what you think sentences should be.
Okay.
I very much appreciate the place from which that letter is written,
Yeah.
but this isn't about you addressing him directly. So
Okay.
you address your comments to the court, and
Good.
it's about sentencing and how it affected you.
Well, it affected me greatly, and I do ask for mercy on him. And I'm sorry that I didn't know I wasn't supposed to.
No,
do
no,
that
it's okay.
personally.
It's all right.
Lock
But
her
just
up.
know that
Sorry,
I
sorry,
forgive.
sorry.
And
sorry.
whatever the
I'm
outcome
very
is,
sorry.
it's up to you. And it's in you guys is in Jesus' hand. So that's all I have to say.
Thank you. Appreciate
You're
it.
welcome.
And Your Honor, I have a statement by Nikita Batts.
I think this is the last one, but I'm not 100%
My name is
sure.
Nikita Batts, and I am the wife of Joshua Batts, a decorated Army veteran, a devoted husband, and the proud father of our 4 beautiful children, Kimora, Jordan, Brooklyn, and our only son, Aiden, who is his spitting image.
I don't think they said
In the early
Violet.
morning
I don't
hours of
know.
November 5th, 2023, Josh was shot in cold blood. He later succumbed to his injuries at the hospital. That morning changed our lives forever, and the hole left in our family is something I will never be able to describe in full. We are broken, and we are grieving in a way that never truly ends. The pain of losing him is still raw and unimaginable. Josh served this country with honor and pride for 13 years in the United States Army, earning numerous awards and recognitions during his military career. He was honorably discharged and looked forward to building a peaceful life with our family. He survived real war zones, deployments, hardships, and everything the military asked of him, only to be taken from us in an act of senseless violence here at home. Josh was more than a soldier. His uniform wasn't what defined him most. He was the anchor of our home. His love for his children was unmatched. Whether he was deployed, working out of state to provide for us, or right down the road, he called the kids every morning before school and every afternoon afterwards to ask how their day went. When he was home on Saturdays, the kids knew it was movie night. They would pile into bed with us. He'd laugh and joke. We would share snacks, cuddles, and would hold us close. Those were the moments when they felt safest, and those moments made our house a home. For our son, Aiden, he was more than his father. He was his hero. They shared a striking resemblance, not just in looks, but in spirit. Aiden has his smile, his walk, his quiet strength. And now he carries the weight of looking in the mirror and seeing the father he'll never get to grow up with. For our daughters, Kimora, Jordan, and Brooklyn, Josh was their everything. Their first love, their safe space, and their biggest fan. They still talk about him as if he's about to walk through the door. They cling to his memory because it's all they have left.
Let's
For
not
me,
get into a
Josh was
religious
my best friend.
discussion.
Fridays were our date nights. Sometimes we both looked forward to, no matter what kind of week we had. It was our time to reconnect, laugh, talk, and simply be us, husband and wife. That space, that love is something no one can ever replace. He made me feel seen and loved, like I mattered in a world where things often feel out of control. I haven't just lost my husband, I've lost my peace, my partner, my protector, and the father of our children. His murder didn't just end a life, it destroyed a family. Since his death, I've had to become both mother and father, protector and provider, nurturer and disciplinarian. I try to stay strong for my children, but the truth is, we all feel lost. They cry at night, they ask questions I don't have answers to, and I cry when they aren't looking because of this pain. This loss is constant. I am now raising 4 children alone, trying to help them navigate grief and trauma at such young ages, while barely holding myself together. I smile for them during the day and cry silently at night. Every day is a struggle, and the weight is unbearable. Josh didn't just die, he was stolen from us. And in that theft, they destroyed a legacy built on love, service, sacrifice, and family. Josh gave everything to this country, to our family, to his community, and in return, he was taken from us in the cruelest way imaginable. I'm asking this court to see the full weight of what was taken and to hold accountable those responsible. Let them feel the consequences of what they have done, not only to Josh, but to me, to Kimora, Jordan, Brooklyn, and Aiden. Justice won't heal our wounds, but it will matter because Josh mattered. Please don't let his death just be another case number. Remember his name, Joshua Christopher Batts, a soldier, a husband, a father, a man who gave so much and asked so little. Remember that this was not just a case. This is our life now. A life we didn't choose, a life without the man we love. Respectfully, Nikita Batts, wife of Josh Batts, mother of Kimora, Jordan, Brooklyn, and Aiden. Your Honor, This was a tragic, avoidable situation. Michael David specifically, as can be seen throughout the video, the only thing that he was trying to do was to calm everybody down. Michael David was unarmed. He had his hands up for the majority of the confrontation. And it was clear what he was trying to do. He was trying to be a peacemaker in that situation. Ultimately, Mr. McPherson took his life. Joshua Batts came out as he was beckoned and was shot in the torso with his gun by his side. Joshua Batts did not lift that gun towards anybody, did not threaten Mr. McPherson, and in no way deserved to die that night. Your Honor, this was a situation over something so incredibly, I can't think of another word other than asinine or stupid. This was
It's
a
okay, I don't
disagreement over
disagree with you.
perceived disrespect that ended the lives of two fathers, of two people who were extremely important to their families. There's not enough that I can say to point out what a tragedy this is and how avoidable it was. Violence is obviously never the answer, and it's never the answer when it comes down to a disagreement over whether or not someone felt disrespected or whether they felt their family was disrespected. They were killed in an area where they felt safe around the people who loved them. And that's something that their families are going to have to live with for the rest of their lives. Mr. McPherson took that shot that night and the subsequent shots, and with those decisions, ended the lives of two people who deserve to live. Your Honor, at this point, there's obviously one sentence in this case.
We do need to talk about 5, 6, 7, and 8.
Right. Your Honor.
Because I don't know that you guys ever, we asked the crime of violence interrogatory, but I don't think it was ever charged.
Correct. And so in those situations, Your Honor, I think that the court sentences not within the crime of violence. As far as those sentences go, Your Honor, I think the court has heard testimony from all of those individuals.
So it just has just a presumptive range F2 and F3?
Correct.
Okay.
Those individuals obviously were there to just hang out, have a good night, and ultimately ended up in the hospital, severely injured, also because of the decisions made by Mr. McPherson and his co-defendant. So at this point, Your Honor, the people would ask the court to impose the sentence of life in prison, as well as those sentences to the attempted murder ranges, and I would defer to the court as to the specific amounts. Your Honor, the one thing in this case that I would like to address, there is restitution. However, that restitution contemplates Kevin Washington, who was dismissed from the case. And based on kind of a shuffling of restitution text, we would ask for a limited extension so that the people can file an amended restitution request that does not include Kevin Washington, since he was not one of the victims of the case that we ended up going forward on.
All right, you can get that filed within 63 days after, please, meaningful consultation with defense counsel. If counsel does not object, put it in your motion, makes it easy. If they do object, written objection is due, stating specific reasons for the objection within 2 weeks of the prosecution's filing. If I can't rule on paper, I will set a hearing within 63 days. For the defense?
Your Honor, there's a few different procedural things I need to address. Understanding the restitution is being reserved, I would ask the court to reduce the amount of time from 63 days. I think 2 weeks would be reasonable if they already know what the issue is, just so that there can be that finality in sentence. part of that is also, we have a limited period in which we have to file the appellate packet. And 63 days is outside of that timeframe. So I'm asking the court to set it within 14 days. We are seeking appointment for appeal and to proceed in form of pauperous. If I may approach, I have 2 copies with the order for the court. I can upload it after the court signs it.
Sure. Frankly, I don't know the restitution would keep you from filing your appeal. I don't think I'd lose jurisdiction on something unrelated to appellate issues based on restitution, but prosecution, can you get it done more quickly?
So maybe if I could have 30 days, Your Honor, next week is conference.
All right, 30 days. Oh, nice, okay.
Everything counts. Oh, don't get this close to us. You're sick. Go behind the statue. Oh, she is behind the statue. All right, guys. Now we can see how big the statue really is in real life. Sort of. We have a better idea of how big the statue is. It's about, I guess, with the spear. With the spear, it's probably like this big, but it's probably like this big on his desk. Thank you, sick lady. Thank you.
Your Honor, I will file this with the court. And then I was just making a request of the clerk for a signed minute order regarding the MIT. When that's completed, we'll just need to make a request for that. As for sentencing, Your Honor, I have instructed Mr. McPherson not to make any statements due to his appellate rights. I think the court has heard the preliminary hearing and the trial in this matter and the trial in Mr. Washington's matter. I know that there is a mandatory life sentence without parole on the counts 1 through 4 because they merge. I would just counts 1 and 2. I'd ask the court obviously to merge those sentences appropriately. As to the attempt murder charges, and I think it's the assault, it sounds like the prosecution is agreeing they did not file for a crime of violence enhancer, so we do believe it would be in the presumptive range. Speaking as to that sentence, Your Honor, and to the sentencing in general, I think respecting the jury's verdict, I think what's been clear from the very beginning of this was that Mr. McPherson became engaged in the altercation here. He did not start it. He was not the person that was inside the club. He was not the person that was responding to anything. He has always maintained that he was acting in self-defense. In the video, you can see that he is backing up. Understanding the 16 shots go off in 2.5 seconds. This all unfolded very quickly. Mr. McPherson was shot in the abdomen. He has always maintained and continues to maintain that he did not know Mr. Washington, and that he was not trying to harm anyone. This was a situation where I think they have accounted maybe 2 shots to Mr. McPherson. The remaining shots, I'm not sure exactly how many they've counted for Mr. Washington, but I don't think that this is a situation where the court is obligated to do consecutive sentences. I would ask the court to do concurrent sentences in the presumptive range, understanding that he's receiving a life sentence. It's kind of potentially a moot point, but Mr. McPherson just wants to be clear that he was acting in self-defense and wants to maintain that at this stage. And so we are seeking appointment for appeal. We will be filing all of the required documentation. And we're proceeding without a pre-sentence investigation report. And I will just be communicating with the court clerk, and I can copy the prosecution on this for getting the minute order signed if necessary. But we will be, if we can do the restitution within 30 days, I think we have a 20-day deadline on our end. And it was my understanding that once we file our notice of appeal, that can suspend restitution. So that's why I was asking for that. I have nothing further.
Mr. McPherson, the law that governs me requires me to hear from you that you don't wish to make a statement. You have the right to tell me anything that you want. I understand your attorney has told you don't, but you just make sure the microphone's on. If you wish to tell me anything, now is your opportunity. Otherwise, you can just tell me you don't wish to make a statement.
I do not wish to make a statement.
All right, thank you very much. Well, there's not the reality is there is nothing I can say to anybody in the courtroom today that really matters in the big picture of things. A lot of times families and victims' family, ask me for closure. I can't give it to you. I can let you know some more bad news. There's an old saying that time heals all wounds. I'm here to tell you it's a lie. It's a mistake. It doesn't. Becomes easier to deal with, and the pain maybe dominates your life less, but you're still going to hear that song. You're still going to hear a turn of phrase. You're still going to hear something that reminds you of your loved one, and that's never going to go away. It does become easier to, maybe not as raw, but I don't think the wounds ever heal. And so I can't give you that either. And in this case, on the other side, I have no discretion. The legislature indicates that the sentence on counts 1 and 2, which do merge, is imprisonment for the rest of your natural life without the possibility of parole. And so I do impose that on counts 1 and 2. I also impose that on counts 3 and 4, with also merge sentencing you to life for the rest of your natural life without the possibility of parole. Only thing I will say as to the jurors' verdicts is, from what I heard, I think they got it exactly right. Even to finding the attempted second after deliberation, but attempted first for extreme indifference. I think the jury was very savvy and got that exactly right. So on counts 5 and 6, with the victim of Asaya Majid, I think these also do merge. Count 5, the attempted second-degree murder after deliberation, sentence you to 12 years in the Department of Corrections. That will merge with the attempted first-degree murder, which was 24 years in the Department of Corrections. Each of those have a 3-year period of mandatory parole. for the purposes of paperwork, and same with Deidre Ross, 7 and 8 merge. It's 4 years on count, or I'm sorry, 12 years on count 7, 24 years on count 8. And again, not that it matters, but when it comes time to dealing with the fact that your actions resulted in multiple people getting shot and 2 people getting killed, all of these sentences are going to run consecutive. That'll conclude this matter.
Well, Judge, don't hold back. Tell us how you really feel. Someone give me the pause. There we go. I'm going to try to find the live stream we did where we saw part of the trial, and link it so you can see. We don't get to see the video, but the video's on this. See the bailiff? I can't point with my cursor, but see the bailiff standing there to the left? We see that screen. We see the video on that screen. So we don't really get to see it, but without the possibility of parole. So that really does mean that. So I think, actually, now that I said that, I think I'm going to switch that. That really does not mean that. I think they do get the possibility of parole after a lot of years, a lot of years. In Colorado. I wish I was a lawyer in all 50 states so that I could tell you for sure. I'm just trying to remember all the judges we were in front of in Colorado, what they said before, and part of my brain is remembering that there is a chance, and the other part is there isn't a chance, but I'm getting my states mixed up. All right. Such a young kid. Thanks, guys. Thanks for coming out. I appreciate it. I'm so sorry I was late. Sleep just took me. It happens. It's been happening more than a lot lately. I need to get my act together. Knife. I don't know, but they're consecutive, so plus he has 12 on top of that. Yeah, Violet, I'm glad you did come today. All right, guys. Behave. I'll get OJ up, and I'll talk to you soon. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace, come join the fun. It's a welcome play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. welcome.